Hey guys, Connor from the Ticket Stub, and you are listening to Lone Star Community Radio on 104.5 KCZW LP Conroe and 106.1 KZCC LP Conroe, and worldwide on irlonestar.com.
Good afternoon and welcome to the Legal Connection. Tony Lynn Collins and Cheryl Ellsworth Jahani, we are both here every Tuesday from 12 to 1 p.m. on 106.1 and 104.5 IR Lone Star Conroe's FM. And we are here to help you with legal issues, questions, thoughts, curiosities, situations you have.
I think to serve people in the best way that we know how with the gifts that we're given.
Right.
You know, that's such a big thing right now, is to try to help people. And this is all I know how to do.
No kidding. So we're here, and today our topic is depositions. We're going to talk about depositions. Tony, I think people kind of think that they know what a deposition is.
I hear the word deposition, and even as an attorney, it scares me because it's like cha-ching. I hear dollar signs going up for everybody.
Expensive.
Yeah,
they're so expensive.
If you're the one that got hit with the subpoena for a deposition, or if you're the one giving it, any way you look at it, it's expensive because it's time that you're using the facility of the camera and the court reporter and the time and all the attorneys involved
there.
And the space,
the time off work.
Like even the radio station offers the facility for us to use this facility to do.
They do that here.
They do
a
location for it. So
Mm-hmm.
so it all adds up.
Mm-hmm. Well, I want to tell our listeners a little bit about depositions, just a general overview. Deposition in the law of the United States, or examination for discovery in the law of Canada, involves the taking of sworn out-of-court oral testimony of a witness that may be reduced to written transcript for later use in court for discovery purposes.
Right, and it's just like being before the jury, but you're talking up front. They always say, and in every deposition I've been in, it's like, ladies and gentlemen of the jury, and it's as though the jury's there, but it's really just a court reporter, and you're sitting in a small room with a couple of attorneys. And I think now you can even do them via Zoom.
Oh, yeah, people are doing them via Zoom, and I think there are a lot of issues about that.
It's kind of crazy because the jury's not there, but as we were discussing earlier, that jury may see the most awkward face you've ever made if they decide to if they're going to impeach you, even if the other side, the other attorney is not really have a reason to impeach you. They'll say they are, and then this crazy, awful picture of you is up on the screen. So you got to be real careful about
especially when it's videotaped.
Uh-huh.
So it's for later use in court for discovery purposes. For our listeners, discovery purposes are the collection of evidence for one side or the other side. It's a collection of evidence that may be used in trial.
It's to prove your case in trial or defend your case in trial. And deposition, any evidence is important. Lots and lots of people ask me to help guide them through the economic mire of going through a divorce because it's so expensive and they're trying to do it on their own. And they're like, what's discovery? And I'm like, oh my gosh, it's going to have to another little refresher course, a quick, here's what discovery is. But basically, it's getting information from the other side that's admissible in court to prove your case.
Right.
Because you may have that your estranged husband has taken all the money that you own and transferred all your property. But if you can't get that evidence other than your own biased testimony before the court, then you're going to lose. And so that's what discovery does. It gives you admissible evidence in a form that is presented by the statutes. So that's discovery. There's 4 different types.
Let's see. They're commonly used in litigation. You just said that. They're almost always conducted outside the court by lawyers themselves with no judge present to supervise the examination. Depositions.
I will add this, though, that you can have your deposition held in one of the courtroom offices, so there's a judge on hand in case you object and you actually want the judge to rule right then. You can actually have the judge on standby and to put it on hold, because depositions can get kind of crazy when they're asking you questions they shouldn't be asking.
Yeah, no kidding. And you can also call the judge if you're at a remote location.
Okay, that's true.
And get a ruling right then, too.
Right.
But, so we're talking about like some different things that our listeners may not understand. But so basically a deposition, it's like examining a witness in trial. And everybody's seen that on TV. Do you swear to tell the truth, the whole truth,
On
and
the
nothing but the
stand?
truth? Yes, Judge EYG, as Curly says, I do. And so then they began, the lawyer that is the deposing party begins to question in a deposition who we call the deponent, but at trial we call that person the witness.
Right. But you're still a witness in the deposition.
That's right.
And you're still under oath. And it's the same questions you will very well be asked in trial. And if you deviate because you're trying to impress somebody or you're making it up or you feel like you have to answer in your deposition, then you're going to be proven to be a liar if in trial you say something different, even if it's a little different. That's why many times, if not all the time, you want a lawyer present to defend you in a deposition if you're being asked questions, because the lawyer will know if it's relevant, not relevant, or be able to stop you from being harassed or what have you. But it's just like being in trial, just like you said. But there's not all of the pomp and circumstance of the judge being on the bench and people being watching and all the tables and all the suits and all that. But it's the same importance. A deposition is critically important.
Okay, well, this is just a question that relates to this. So in a deposition, somebody says something, and then it's recorded. And that's the purpose of the deposition, is to record the testimony.
Truthful statement.
And it's recorded, and you have it transcribed by a court reporter. And then the same person is sitting up on the witness stand in trial, and they say something different. So what would the attorney that realizes that that's different, or basically that witness has just impeached themselves, shown themselves to be
Well,
unreliable?
they haven't impeached themselves; they've lied. But it's up to the attorney to impeach them. They're showing, which all impeaching is a big legal word for I'm going to prove you're a liar. Because just like in life, the truth will set you free. The most important thing you have is to tell the truth. And you're on the stand, that's all you're offering, unless you have evidence to support it. And it may be your statement is the only evidence. So if you're proven to be a liar, then if you rely on something small, even if it's a mistake, they're going to say, oh, well, she'll lie on something big. And usually it's just a twist of words or something that's just ridiculous. But depends on what side of the deposition you're on. If I'm the one doing the deposition and I'm the one proving they're a liar, I'm going to say it's huge. But if it's me or if my deponent or my client, then I'm going to be like, objection, that's not impeachable because it's not the same question. And so the way that works is, and I'm going to reflect back on one that I had a lot of impeachable statements in a bankruptcy case. Depositions in bankruptcy are called 2004 exams. They're not called depositions, which is kind of weird because that's all they are.
Yeah.
And that's because in the bankruptcy code, they're under the Federal Rule 2004.
Okay.
And those are the rules that you use, kind of like in Federal Rule 30 is your rule for depositions in federal court. And then in your depositions are going to be under rule, I think it's maybe 260 something. I
in
forgot.
state court.
It's been a long time since I've actually noticed it, but it's the Texas Rules of Civil Procedure give you the rules on what you need to do to get somebody in for a deposition and the rules that you follow and that kind of thing. But in this 2004 exam, it was done not with a court reporter and not with, but it was sworn testimony. And because the bankruptcy trustee was the one that had called the deposition and let the other parties know, I didn't even have to be there. But I was the opposing side, and so I wanted to be there. I was going to take full advantage of this. The trustee is deposing the bankrupt to see if they're hidden assets. Why wouldn't I want to be there? Because we had a stake in getting some of the assets back to pay off the debt that wasn't paid. And so he actually just had a phone. He used my cell phone. My cell phone
and
wasn't
recorded
recorded.
it.
And he put it on the table, and he had his the trustee had a secretary who was also a notary swear the bankrupt, and that's what the person's called that declares bankruptcy in. And there's certain rules and how long it would last, and there's certain areas that you have to stay within that purview of questions, but it's pretty broad. And so that's literally all they did was they swore the guy in. He seemed so at ease because all it was a little cell phone in the middle of the table, and then me, looking for his debt, bad guy, and then a real kind of a new trustee assistant. It wasn't even the trustee, just a young guy right out of law school, asking like 12 questions, and then I got to ask all the questions I wanted because that's part of the rules in a 2004 exam. And what happened was he was so relaxed and he was being really rude that all came out. Everything he was saying came out because you can get that little tape transcribed by a court reporter.
That's right.
And then it's admissible in court because
That's
you
right.
file it with the court as a business record.
That's right.
And it was pages and pages of basically statements that were controverted on what was filed and what he was saying.
So
now,
how did you handle
so
that?
what you do in federal court is, and I believe this is in the same, and it is actually the same when you have a federal trial. There's certain rules of a procedure. It's a little different from the discovery rules, and that's how you collect the information. The procedure is how you get it into court. And in federal court, you have to have, nowadays, everything's a little bit different from when I first, started practicing. You have to have it all in a digital form, and you have to have it presented within 3 days of the trial. I believe that's the deadline, but don't hold me to that. But there's a certain limitations period when you have to have all your exhibits labeled and put in digital form and given to the court so the judge can pull it up. Different judges do it different ways, but in this particular case, the judge, I would just tell him what the exhibit number was, and he would put it on the screen and flip to it for me. But the only way you can truly impeach somebody is if you ask the same question. So I knew he was going to lie, but I knew where he had lies.
And the question was right up there on the screen.
I had it, but
right?
It was a little bit better. It was a little bit more than just saying, "Oh, he lied. I'm going to be ready." I had to actually go through 1,000 pages of testimony.
Oh, I know.
And highlight it so I knew exactly where to tell the judge to go, and I would ask that question. And if he answered it the same way, that's almost impossible to answer it the same way unless you really watch what you say in a deposition. If he answered it any differently, significantly differently, is what I wanted to do so I wouldn't aggravate the judge because it was a bench trial, I could say, before I'd ask the judge to go there, I would read the question. And if he answered it truthfully, I'd move on. If he answered it untruthfully or differently, then I would ask the judge to pull up and ask it the same way. And I'd say, isn't it true that you had a deposition on this date? And, or in this case, it was a 2004 exam. And isn't it true that these people are present? And, isn't it true? I didn't have to say that word first, but it kind of helped guide me and the judge. And I was basically giving him a roadmap of where I was going with it. That on this date, we took a deposition, you were there, and you were under oath, and you understood, and did not ask you this question. And he didn't know where I was going with it, and his attorney didn't know where I was going with it. His attorney wasn't there. He should have been, but he wasn't. Mm-hmm. And he didn't even ask for a copy. So I just had like this playground of questions because I presented it, but they didn't look at it.
But Tony, when you're asking, if you say, isn't it true on this day, and you set it up, then you put it up on the screen.
First, he had to have lied to the way I asked it.
Already. Before you even went to it.
And then my second step is to go to authenticate the deposition and then ask the same question again. And then when he answers it differently, because he can now see his answer on the screen.
Right.
Because it's
that
up
was
there.
my question.
He's going to try to change, but he can't because he didn't know what I was going to ask him because my question wasn't before him. I didn't give him a list and say, here's all my questions, and I'm going to ask you these again.
Right.
He had no idea I was going to do that.
Right.
And his attorney, which I don't know, I guess bankruptcy attorneys don't go to adversarial trials that often or something, but he didn't know that he lied about it. And it basically won our case for us. So
that's great.
So that's how you do it, though, is you have to ask the question basically in the same format. It has to be the same question, and their answer has to be different. Otherwise, you're wasting the court's time, and you lose a lot of respect with the judge. Mm-hmm. If you try to present in trial this inconsistency or this lie, you can call it an inconsistency. It's a lie, Mm-hmm. And then this judge was even like, are you calling him a liar? And you don't want to say that because it's so impolite, and you want to, because there's so much pomp and circumstance, particularly in federal court. But if they're a liar, you call a spade a spade. I mean, if they lied, they lied. Mm-hmm. And it's like, are you calling him a liar? And you're almost like, the judge is going to be mad at me. It's like, yes, I'm calling him a liar. If it's true, if you've proven it. So that's good, but that's how you impeach. And normally you would hope that an attorney would prepare their client in the deposition to not say something that will be incriminating, which is why you have very few criminal depositions, because you have a Fifth Amendment right to not incriminate yourself.
Right.
But you can get a criminal deposition for an important witness, which you get, but they're very seldom granted. You have to ask the court first and that kind of thing. But that's how depositions work. And
Okay. Well, in almost all cases pending in the United States federal courts, depositions are carried out under Rule 30. You already said that. Of the Federal Rules of Civil Procedure, about 35 states use versions of the Federal Rules of Civil Procedure in their state courts, and that's very
so
common.
They've made the state statutes correspond with
With
the
the
federal,
federal
rules,
statutes.
so they're not that different. In Texas, it is a little bit different, though.
Is it?
Yeah, and in Texas, and I think I had this right. I brought it up because I thought, wow, that's a really good thing for attorneys to know too. And if you're doing it on your own, just kind of know because, federal court and state court are the same. You're basically going after the same thing. You're trying to get justice, and there's a trial, and there's going to be, one side arguing that the other side has done something wrong, whether it be criminal or civil. And the only way you get into federal court is if you have a federal question or it's you have diverse parties.
Federal jurisdiction for some reason.
There's different reasons that you can get into federal court, which I actually prefer much of the time because you don't have the local bias when you get to a federal court and you don't have an elected judge. So it's more likely that you'll get a more fair adjudication because there's not the bias. Like I think we were just talking about this last week, where you can get into the United States Supreme Court directly from a state issue if it has to do with you have a beef with the city or the county or local government, because they found in a case last year, and I can't remember for the life of me what the name of it was, but it was in Ohio, but it was a Supreme Court case, and so it's the law of the land now. It overrules, state cases. Or should have precedent if it has the same, if it's on point, that you can take a land case that's against where your beef is with the city, if it's the city or the county or the state has somehow wronged you, you can take it directly to the U.S. Supreme Court. You don't have to go through the state court or the federal court. And the reason behind it was because there's a bias on the local level. You have local commissioners, local officials, local mayors. There's small representatives that they all know each other, and you're not going to get a fair shake if you're not in the popular group, so to speak.
Right.
And so they can go, and it's not a much used rule because really they just found for it, but you can do that for that very reason. And so that's why federal court may be where you want to consider, not to be afraid of it, taking your case, because and you may not have a choice. It may be that you have a federal jurisdiction with guns or whatever where you have to go there, but there's a lot of cases that have dual jurisdiction because of the amount of controversy, diversity of the parties, and that kind of thing. But that's what you have to look at. There's not a lot of bias. Federal court's kind of scary, but it's the same ball of wax. You're still trying to get evidence before a judge or a jury to support why you've been wronged. Depositions help you do that. And I will throw in there, just for good measure, and because our listeners need to hear that, I have lectured, so to speak. I haven't really lectured, but trying to help out a lot of my friends that are pro se and trying to go forward on their own.
Oh, you've lectured. I know. I can personally witness, attest to that.
You can ask as many questions as you want. If you can ask for as much production discovery, request for production as you want, there's no limit.
But if you do, then you've got to send out a different kind of note. Well, you've got to send notice to all the parties.
You've got 4 different types of discovery, and this isn't really what I'm sure about, but I'll just hit on those really quickly. If you need to get evidence, you can request production. It's very, very important. You need to ask for bank records a lot of times. You have to ask for phone records. You want to ask for, they need to produce a will or whatever it may be, but you can ask for something that's tangible and you're asking for it in court. Those are requests for production. There's really no limit on what you can ask for.
Right.
It may not be relevant to your case, and that's an objection they can raise, but you can ask for 200 things if you ask it. I mean, I don't know why you'd want to do that, but if you had that kind of a case, you can ask for a multitude of things, right? When you have a different type of
insurance
request,
contracts, things like that would be produced.
Another request, and that kind of goes to requests for disclosures. Requests for disclosures are almost always required. They're in the local rules, and those are where you disclose if there is an insurance contract. You do disclose who your at that time who your witness is going to be. There's a lot of things you have to put in your request for disclosures. That's a second type of discovery request that's usually always required by the local rules. You can't get around that one. You have to exchange that kind of information. Requests for admissions are another type of discovery, and they're usually yes or no questions, but they're very, very important. They're the kind that you cannot be late on. If somebody asks you for admissions and you're one day late in answering them, or you don't answer it, it's deemed admitted. And so they can ask you something like, "Did you kill, President Garfield back in 1920?" And if you don't answer it, it's deemed admitted. So you got to be really, really careful about answering those very timely. And they trick you too because it's not a yes or no question, and so you have to object. I can't answer this because there's more to it than that. But you've got to at least get an objection in or it's deemed admitted. The fourth one is what we're talking about today. The fourth one is interrogatories, and I'm going to say / depositions. Interrogatories to me are like depositions because they're asking somebody a question under oath that will be admissible in court. But it's a question where you only have 25 questions you can ask in discovery or the subparts. And if you have an accelerated case, you only get 15. So you're like, I can't ask questions to somebody, the opponent. What's going on with this? I'm so limited. And only a certain number of depositions are even limited. You only have a certain number of hours that you can depose somebody. There's a lot of rules. In the
it's like 7 hours.
But deposition on written questions are very different. Deposition on written questions are not limited. You can ask as many questions as you want, but it's because it's called a deposition and not an interrogatory. It's still a sworn answer to your question.
Well, so okay, deposition on written questions. Our listeners, they're picturing, two people sitting there with their attorneys beside them. Now we're doing it on Zoom. I don't know how that's.
It's not a formal deposition in a deposition on written questions.
Right.
It's done in a certain way, and maybe a lot of times if you're on your own and you don't have an attorney, you can ask a court reporting service to prepare the format for you so it can be served. Deposition on written questions can be served to third parties. It's done all the time for like real estate deals where you've got to get information from a third party. You need to get a mortgage company to give you something. You need to get the real estate company, somebody that's not a party but it's a witness and it's not answering you. Deposition on written questions is a cheaper way than doing a deposition. I like them better. There's not all the it's Zoom it's COVID friendly because you're not involved. You're doing usually you're just swearing to your answers, and those are admissible.
So you get a court reporter to do the formatting, and then the person who's being deposed, what goes before a notary.
Yeah,
and
but it's all written out in writing. And it's just it's served on you, and you have to respond to it just like in a deposition. So, but you have the time to think about it and look at it and make objections. Very different in an oral deposition where. I'm talking to you right now, and if you've got the little recorder going, which you can do that, you're pretty comfortable.
And if I've been sworn in by a notary, then I'm under oath.
And if you get kind of loose after about 5 hours, and this is really uncalled for, but what if somebody's drinking? They shouldn't be, but if you don't have an attorney present, the other side's not going to tell you not to unless they think it might affect what you're going to say, particularly if you're not intoxicated. So I've never heard of that, except for we did have a case where that was introduced during a mediation, which should never be.
Yeah, no
alcohol.
kidding.
But I'm just saying that deposition on written questions can get around the interrogatory issue because interrogatories are sworn statements that are presented that can be admitted
But there's
in court.
a limit.
There's a limit. And but the deposition is much more broad, and that's what we were getting at today. Depositions, depending on which side you're on, can open up all kind of things that you wouldn't even have known to ask because it's a casual conversation with your opponent who's usually not on edge if they're not the party. They're just a third party that's coming in and has nothing to hide. That's how they feel unless they've been prepped by their attorney properly. So anyway, that's what deposition on written questions are, and I kind of threw that in there. But I was going to throw in there what the differences are. And there was one thing that it had to do with the objections in Texas, and I
Now, these are the differences between depositions on written questions and live depositions?
No, this is the difference in your objections in Texas. They're a little different than in federal court, and they're different in different states because Texas attorneys got a little crazy, like the Wild West, and they were making insane objections about everything. And so there was a case that came through, and I'm looking at it I'm looking for that actual case right now, that said that because the Texas attorneys have gone crazy, and they're objecting to everything. So their party doesn't have, the person they're representing doesn't have to answer anything. They made rules that you can only have certain objections, and I'm going to paraphrase here because I can't find the case right off, but I just know it. You can object to form, and you can object to
leading.
leading and relevancy. Those are, and form has lots of little subcategories under it.
But
Leading.
is it form, leading, and relevance, or is it just form and relevance?
Well, form, it's form and relevance, but whether something's leading or not, it's going to fall under it. So I know there's only supposed to be 2 objections, but the reality is you can object to more than that, because under form comes,
everything,
a lot of different things.
And
right.
the attorney may actually ask you, what's your objection? If you say form, he may say, okay, what?
Right. But if you have an attorney there that's objecting, the good thing is that you can, if they're objecting, the person that's doing the deposition may lose track, like in the debate with the President Trump and
Biden.
Vice President Biden. They were losing track of some of the questions because it was going off on different little veins, which was, like an octopus is what I'm going to say. So the question never got answered. But I wish I could find that. I'll read this real quick because I think it goes along that sort of vein. Once the litigation team knows the law, the team can construct a theory of the case and work to object to evidence. The case theory serves as the backbone for each deposition outline. And that was kind of what we were talking about earlier this morning, is you really need to have at least your base, like 12 questions that you need to get out of this deposition. Do not waste your money. They're very expensive. The person that calls it's got to pay as a court reporter. The person that's being deposed can get a copy of it. But if you're calling a deposition, you're paying for that videographer, that court reporter, and the transcript. And you may, like I did a deposition recently with one of my clients where I'm like, okay, I know you don't have much money. I'm really carrying this for you. Whenever you can pay me, I covered it for her. What a mistake, because I never got paid.
Yeah.
And I was out a full over $3,000 just to pay. It wasn't even the videographer; it was just for the transcript, because you got to pay the person that's doing the stenography for you.
Yeah, or you lose your professional reputation.
Right, and so you've got to hold up. But you were telling me that you had a court reporter, and telling me about that. You were like, "Here's the way you get around that." You had a court reporter.
Oh
you
yeah, yeah. Dick
and
I were just talking about that because they do depositions here at the studio, but you can get a videographer that is also a notary public, a notary. And if they can administer the oath and swear the person in, then you can just video it.
Okay.
And then afterwards, if it looks, because a lot of cases don't go to trial.
Right.
And a court reporter is very expensive. The transcription is very expensive. You said you just spent $3,000
for the
and didn't even
transcription.
have it videoed.
Right.
Yeah.
It's insanity.
Yeah, it is insanity.
And that's I think if you would know after you had just the videographer,
Right.
whether they even lied. You may have gotten nothing out of that deposition that really had any meat in it, or maybe you only want a part of it transcribed, which saves you so much money. And I really love that idea. And you brought that up to me. I don't know why I didn't think of it before, but it was a really good idea. The questioning attorney may also raise an objection to the opposing counsel behavior, including use of excessive objections or objections raised for the purpose of coaching witnesses. The Texas attorneys are renowned for this because they hear a question coming where they don't want it to come out because they didn't even expect it to come out this soon, but it's something that's going to hurt them, and they'll object. They'll ask for a break. Can we take a break real quick, a bathroom break, so they can go coach their witness? And that happened to us in a recent trial where you're annoyed because then the witness comes back with this full blown, like Joe's little, earpiece thing they showed all on the internet where he had, maybe a wire or something. But it's like,
oh, I didn't see that. Are you kidding me?
No, it came out, and I don't know if it's true or not, but it was all over the internet where they were showing a wire on his wrist, and they were showing a wire coming through here. And when the President Trump's team said, will you swear that you don't have a wire, whatever, we can check you. They said at first, yes, no problem. But then they said right before the debate, no, we're absolutely not going to do that. You may not check, Vice President Biden for anything. And of course, why would you not let someone check unless you had a wire? And then they were showing, if you Google it and do Facebook, you'll see like a little wire and stuff. So I don't know for sure. Maybe they put that up. I'm just saying what I saw. Okay. Anyway, it says, that they can coach the witness. Chastising an attorney for excessive interruptions and coaching the witness for his objections was one that was in Iowa, Supreme Court of Iowa. The questioner is also permitted to raise an objection if the witness has answered the question is non-responsive. And I'll answer that all the time because I know that if they are diverting their answer because they don't know, or they're just saying, you're under oath today. What color is it that you're wearing? To try to see if they're colorblind, and they say, well, the sky is blue. Well, objection, not responsive. The answer is, what are you wearing today? They may not want to be answering because they know they have to lie, and they're going to have to, and they're avoiding it. So to look at that, and that's an objection.
And the difference is the objection to form and relevance and leading. Maybe, but form and relevance is usually done by the attorney that's defending the deponent, the person that's being deposed. The attorney defending will object to form and relevance. The attorney deposing will object to
all the other thing, whether it be
non-responsive. You didn't answer my question.
Right.
I asked you a question.
Right. Oh, the one that's asking is going to be non-responsive, and sometimes it would be. In fact, that's probably going to be the main one. That's non-responsive.
Sometimes it would be what? Can you think of another one?
I can't even think because when I'm asking the questions, what are they going to say?
Yeah, I think it's non-responsive is your objection. Answer my question.
Yeah, and I think that we've gotten some clients that get. There's profanity. They don't want to answer it, and then you object to the record for proper decorum. I don't even know how you object to that, but if that's when they start getting, because they're mad at the questions you're asking. That's when you usually ask for a break, or you let them go crazy.
Yeah,
because you want that. Because just like we were saying, bad. You get the if it's a videographer, then you get to freeze frame that face. Like there was a T-shirt that came out with, I guess, a basketball player that was making a face in Miami Heat, and they've got it now, and the guy's sneering, and now they're like, I don't know why, but
kind of like Michelle Obama's face when Donald Trump was being sworn in. Do you remember that?
No, was it?
No,
it was
that. Really terrible.
It says, anyway, there's a list of proper deposition objections, since we're on that line of thought. It's probably the rules of a procedure for the proper jurisdiction. Each jurisdiction in every state and in federal court has their own rules. But in Texas, it's going to be the rules of civil procedure, and we know that there's two main ones, and you can't object like crazy anymore. They've got some Supreme Court cases in Texas that said, no, we're gonna take away your ability. Here's the thing about depositions that I don't like if I'm the defendant on that. I don't have to worry about criminal cases, but if you're defending a case, first off, the other side will depose your friends. If you're a doctor, your doctor friends are taken away from. They're going to harass you by sending out subpoenas, which if they're not a party, you have to subpoena them. Notices to your best friend, perhaps the lover of your client.
The attorney's best friend?
No. Your party.
Okay.
The party is being sued. Your party's being sued, right? Let's say it's civil. You usually can't do any criminal, so it's always going to be a civil case where you're trying to depose these people. And let's say it's a medical malpractice case. Let's say it's a family law case, and you know that you're. Let me just use a completely made up example. The spouse, the male spouse, is a doctor, and he's cheating with a bunch of nurses at the hospital. You see that on ID channel, and there's murders and stuff going on. Right. And so you want to depose the mistress. Maybe you want to depose the mistress's husband because they know about it. They're not parties, and you can't get that information. A lot of times they don't want to get involved. They just want to be left alone because they're mad enough about the whole thing. But you need to get information from them because they have information that's going to be helpful to your case.
Right.
And so if I'm that person, if I'm the party that's looking for the information, I will depose that third party, and they will object. They don't want anything to do with it. They just want to be left alone. It's money to them. They have to be taken off work. They don't want to be involved. They're just third-party witnesses. But if it's important enough, you've got to subpoena them and get them deposed. And you can ask them for information like bring your telephone records. If you've got some kind of authority, maybe the medical records are relevant, and insurance records, you can ask them to bring stuff along. And they're just people. They don't want to get involved. But you can subpoena them and ask for it. And if they don't quash the deposition, they have to show up, which was another thing I wanted to bring up. If you're a third party and you get the subpoena in the mail and you're just some doctor at the hospital, some nurse at the hospital, you have no idea why you're being subpoenaed. You're just minding your own business. You can actually, if it's a surprise to you, if you file a notice to quash the deposition, and this is in Texas, it's a Texas rule of civil procedure, so I'm not sure what applies in federal court, but I think there's a like one in federal court. I can't say that for sure because I've never tried to quash one in federal court. It's a little bit more civil, which is weird. You wouldn't think federal court being a higher up court would be more civil, but they are. The decorum and the procedures and the way that people interact are more civil. And but you can file a notice to quash with nothing more than by the rules of civil procedure. I think it's 215.1. I can't remember the one exactly, but whatever the rule is, you can just file, if you're doing it on your own, a notice to quash. And I'm filing this within 3 days of receiving notice of my service, and it's automatic. It's quashed. And you can keep doing that forever. The problem you run into is that you keep quashing it within the 3 days. I get them all the time, and I'm always quashing for people. They'll eventually move to compel the deposition, and the other side will file a motion to compel. I've tried to notice this. They won't give me a date, and they'll list all the times. And then the judge is probably going to – you won't get fined for it. I mean, they didn't ask you. You know, if they didn't ask you when you could do it, or maybe you just
right.
So if you're a third party, there must, if an attorney really wants your deposition, they'll come after you for it. But it's nothing to be afraid of, because you don't have to show up if it's quashed within 3 days. Depositions aren't noticed. You don't have to ask the court for it. Like, it's not something where you have to move to get it. Only a motion goes before the judge. Depositions are noticed without court intervention. It's a little bit different in criminal court. Everything has to go through the clerk. But I'm kind of getting off on
But
tangents
subpoenas
here.
have to be filed with the court, right?
No. If you're going to subpoena somebody to show up for a deposition, you might file it for the court to show that they didn't show up, but you don't know. You can just you subpoena them. I mean, if you're bank records, for an example, bank records, you have to give notice to the bank. You have to give notice to the opposing side within 10 days of them being subpoenaed for the bank records, because you're trying to get the bank records of the ex-spouse or the estranged spouse, because they're hiding stuff. Or maybe this person owes you money and you're trying to get their bank records because they're hiding all their money. And you don't know for sure if they've got an account at this particular bank, but you've got to, they're lying to you. So what are you going to do? So you subpoena the bank, but before you can get those records, you have to give 10 days notice to the opposing side for the opportunity to object. Right?
Well, what about just filing it at the same time, serving the subpoena and serving the notice?
You can do that too, but the bank won't give you your information until 30 days after the 10 days is up. So you can say, I'm giving you notice, but I'm also subpoenaing the bank. But the bank isn't going to act on it, because that's in the Texas Financial Code, until after 10 days has passed. Because I think, if you subpoena medical records of somebody, because you think these people are crazy, it happens in family court all the time. And this is kind of off the point of depositions, but if you subpoena medical records, you have to have a release from that person or their estate before the medical records, because they're confidential, can be released. And then and I remember in one of my own divorce, my second divorce a million years ago, I had gone to a counselor because I was devastated. I didn't want a divorce. I really wanted to stay married. I don't know why in hindsight, but I did. And so I was seeing a counselor because I thought, why bug my friends about this? I'm going to go see a professional. And my estranged husband subpoenaed my records from my counselor. And I didn't think anything of it, because it wasn't anything I was hiding. It wasn't anything I told him. And I didn't object. And in hindsight, I should have objected, because he was trying to use against me stuff that I had told in confidence to my counselor. And I guess you could technically subpoena a priest for a confession. I don't think you'd get it, because that's
don't you have the
rule.
Confidential, the
that's
clergy?
a privilege. Yeah, but if no one objects.
Oh, well, right. If no one objects.
You've got a privilege.
Yeah.
But if you're not using it.
Right.
Then, that's the whole point. People object. Don't just let somebody railroad you and get all the information.
Right.
I think there might be a clergy rule that a priest shouldn't give it up, but if no one objects, I think it could come out. But why would somebody? Well, I'd say why would somebody's going to disclose to a priest, at least if you're Catholic, because you don't want to rot in hell, and you've got to purge your soul for mercy. And so if you killed somebody or did something, had a mortal sin, you're going to go confide in your priest and ask for forgiveness, and your act of contrition to get forgiven. But I suppose if somebody knew that you confessed and you were a really devout Catholic, they could. I've never thought about it. I guess they could.
They could try. I know there's a privilege, but
yeah, the priest.
You're right. If nobody objects, then
they could give it up.
That would be ridiculous.
Anyway, that's off the beaten track of depositions, but. I don't like depositions. I will be the first to say I'm not a big deposition opponent.
This was my next question, or my question to you for our listeners. So we go to all this trouble, we spend all this money, we do these depositions. Why? Why don't we just go to trial and ask them questions there?
Oh, I love that question. First of all, there is there's a lot of questions you don't want to ask in a deposition because there's an element of surprise
Exactly.
that you have to hold back because you're finding out if the other side knows something that you haven't disclosed to them. I mean, you found something out and you're wondering why aren't they using this in their favor because they don't know. Because they just don't know. And so you're kind of poking around. The element of surprise is really important. I think a lot of, I want to say, attorneys that are just trying to run your bill up do depositions just to run your bill up.
I do too.
That's all they're doing.
I do too.
And they're not, and they may be trying to fishing around over some stuff, but they're really not more. And I think depositions get a bad rap because if you're the client and you're having to pay your own attorney for a deposition, you wonder they're just trying to run my bill up. That may not be the case. You may be out of interrogatories. They may be hiding something that they're not answering the questions, and you've moved to compel, and they're still not answering the questions, and you need to get it on video to show they're lying. That they're like Jeffrey, whatever his name was, the one that committed suicide that had
Dahmer?
No, not Dahmer. That was criminal. Thank you, Epstein. The
yeah.
one that just would say, "I'm taking my fifth."
Yeah.
And in the civil cases, he wouldn't answer either, and he would, stage being offended by the question and leave, which that's sanctionable. If somebody asks you to, that's like leaving the courtroom. You can't do that. It's like, so anyway, I want to throw in there about depositions too, and this is not really off the beaten track, but it's something that I wanted to share. Sometimes your attorney is not prepared to ask questions because you haven't given them the questions that need to ask. Maybe you haven't paid them, but a $2,000 retainer, and your attorney says, "You want me?" And you want the deposition. You need to depose him. You need to depose him. And maybe it's a probate case, and you want to depose them before they get rid of all the stuff, and they don't know that they're going to go to trial with it, and so you need to depose them quickly before they're prepared to let you know that they've sold everything to American Greed or auctioned off or whatever. It's an element of surprise, and if you can get them in there and depose them pretty quickly, you can get some pretty good information. Or maybe they're just snide and they're pompous, and you want to get that attitude on the screen, but they're not snide and pompous when they're being polite in front of the judge.
Right.
They just don't expect it. Okay, you put in there's going to be a video, and they're just not expecting it, and you get this attitude that was really beautiful for the jury, but. Your attorney may not know what questions to ask because you've got this really highly complex set of facts for a divorce, and your client is throwing all this stuff at you all of a sudden, and they're like, already emotionally unstable because they're going through a divorce, which is not how they normally are.
Right.
And so you ask them to write out the questions that are important, and they never do it. It's like 95% of the time I'll say, could you organize some questions for me, and then give me offsetting documents that you have, like anything that you collected, because I can't get it into evidence. I need them to admit it. So give me these bank records, give me something that incriminates them, give me something. And your client never gives you that information. They're like, well, I just thought you were going to take care of it, and it just infuriates me. I'm like, you've come to me as this poor downtrodden, I've been abused person, they're hiding all their assets, and you're saying, I'm telling my client, bring me paperwork so I can put it in front of them and get it admitted because you've given me nothing and the trial is in a month or less.
No kidding.
And then they don't give it to you. And then you're like, now I'm going to have to organize my own questions, and they may not be the right questions, and it's really infuriating to me to have a client that's like, and they always tell you, oh, you're my angel and all this stuff, and it's like, no, I'm going to be your devil if you don't help me because I don't know what questions to ask, and you're paying me. Most of them don't pay me. They're like, I'm going to pay you whenever I get it, and they never pay me. But be organized.
That's not always true, though, Tony. Yay.
That's not true. A lot of people do pay me. A lot of people do pay me very well. So I will say that. But the ones that I'm trying to help out, the ones that seem so destitute, the ones that are now taking medication because they can't believe that their husband or their wife has cheated on them, and they've been married for so long, and I'm trying to be their friend and their counselor and their attorney, and they don't have no money because they're being starved out. I'm trying to help them, but I know that there's money to be had because it's being hidden. I can't get them to help me because they get crazy on me, and then they start drinking, and then they're getting crazier on me, and it's like, all right, let's reel you in. You need to go to church. Just go to church, give it up to somebody else, and then I think you'll have a lot more stability. Prayer is really important. All right, so be organized. Consider the sequence of your questions and make sure you are fully prepared. Organizations ensures you cover the topics you intend to, and also helps to make sure the record is clear for later use in preparing for trial. So
Okay.
organization is really, really important.
Okay, well, that's true. Organization questions. I wish we had a little bit more time to spend on that, but we're going to have to wrap this up. We thank you guys for listening. We have been talking about depositions and what those look like and their purposes. We want to remind you to
Serve God by serving others.
thank you. Have a great week, guys.
Today's show was recorded and broadcasted live on irlonestar.com, Conroe's FM 104.5, 106.1, and all rights and ownership are reserved to Lone Star Community Radio. For more information regarding this program and Lone Star Community Radio, visit us online at irlonestar.com. Lone Star Community Radio is Montgomery County's community radio station, serving the community with local programming on TV, radio, and online. If you enjoyed today's program, please support us by sponsorship or starting your own show. Contact us today by phone or text at 936-666-1084 or email the station at lscrstudios@gmail.com.